Today, we will talk about the last will and testament, definition, types, and how to write one. A last will and testament is a legal document that communicates a person's final wishes pertaining to their assets. It provides specific instructions about what to do with their possessions. It will indicate whether the deceased leaves them to another person, a group, or wishes to donate them to charity. A last will and testament can also handle matters involving dependents, the management of accounts, and financial interests. Some states allow for non-standard or unusual wills, such as a holographic will, while others do not. A will and last testament directs the disposition of your assets, such as bank balances, property, or prized possessions. It will detail who is to receive property and in what amount. If you have a business or investments, your will can specify who will receive those assets and when. A will also allows you to direct assets to a charity of your choice. A will names an executor of the will, who is responsible for administering the estate. A will and last testament can form the foundation of an estate plan and is the key instrument used to ensure that the estate is settled in the manner desired by the deceased. Any assets that have designated beneficiaries, such as a life insurance policy, qualified retirement plan, or brokerage account, are not included as probate assets and pass directly to the beneficiaries. While many people obtain assistance with their wills from a lawyer, this is not necessary to make most wills legal and binding. Any property that your will directs should go to certain beneficiaries, whether people or organizations, most likely will be tied up in probate court for months before it can be distributed according to your wishes. In addition to time and effort, the probate process involves legal fees relating to a lawyer, the executor, and the court. The four main types of wills are the simple will, the joint will, the testamentary trust will, and the living will. A simple will is one that can be done easily online using one of various templates. A joint will is one document that involves two people, generally spouses. A testamentary trust will contains one or more testamentary trusts that take effect after your death and the probate process, unlike a living trust, which takes effect during your lifetime. A living will concerns only your medical care and decision-making should you become incapacitated. It is a legal document that provides instructions for your care and the termination of medical support. Wills and trusts are both important estate planning tools, but they differ in important ways. Trusts are legal entities created by individuals known as grantors that are assigned assets and instruct in the disposition of those assets. A trustee is designated by the trust document to manage and distribute those assets to beneficiaries, according to the wishes of the grantor as detailed in the document. A will becomes active only after one's death. A trust, on the other hand, becomes active the day you create it. Trusts tend to be more expensive to create and maintain than wills. Importantly, unlike wills, trusts do not go through a probate process and are not usually a matter of public record. A trust, however, can only deal with property or assets that are assigned to it. Here are 5 key takeaways. 1. Having a last will and testament gives you some control over what happens to your assets after your death. 2. If you die intestate, or without a will, your estate, including the distribution of all assets, is settled by the courts. 3. If parents with children die without a will, the courts will appoint a guardian for those who are minors. 4. Trusts and financial accounts, including life insurance policies, with named beneficiaries do not pass through probate court. 5. Today, wills can be drafted affordably using an online will maker. Hope this would help. Thanks for watching.